with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on this Zoom? Say something if you hear it this time.
Yes, Your Honor.
Today's courtroom meltdown is brought to you by none other than Javar Grayson, our favorite returning sovereign citizen who once threatened to sue a judge and is now taking legal aim at a traffic cop. But here's the kicker: he doesn't even believe the court has jurisdiction, yet he's filed a lawsuit in that very court. Welcome to the rabbit hole of logic-free litigation. This is not your average case. We've got pseudo-legal arguments, claims of birthrights, a motion for default that collapses under scrutiny, and a judge who somehow keeps a straight face while unraveling this sovereign circus. Judge Coleman isn't new to these antics, but today's sovereign stew is piping hot. Stick around, because this sovereign citizen isn't just out of his legal depth, he's swimming in the shallow end, with no floaties. Oh, and did we mention he claims he's immune to traffic tickets because he's a Moorish American nation? Yeah, buckle up. This courtroom drama is going off the rails, and Judge Coleman is steering it straight in.
Let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on the one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something in this?
Where the sovereign logic begins to short circuit. Grayson insists this court has no jurisdiction over him, yet files a motion within that very court. It's like claiming a restaurant's food is poison, but still ordering takeout from them every day. Judge Coleman rightly questions the contradiction. Why approach a court for legal remedy if you deny its authority altogether? This is textbook sovereign citizen playbook. Flood the court with contradictory motions, hoping something sticks, but courts run on law, not vibes. The judge is patient for now, but we're watching a legal argument that's about to implode under its own nonsense.
That's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36 District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yeah, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did read the copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismissed in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
The city attorney calmly outlines the obvious. There's no viable claim. The defendant is protected by governmental immunity. And Grayson is essentially trying to relitigate a traffic ticket in civil court. Not only is there a procedural no-go, it's legally baseless. This is a clear example of a sovereign citizen mistaking personal outrage for legal standing. Just because you're mad doesn't mean you have a case. Judge Coleman is hearing all of this. And trust me, the gears are turning. This case is not just weak, it's a legal go.
The default request, I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, no factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is a some type of traffic ticket. I started off Brian Ambrosius stopping me.
The class in judicial patience. Judge Coleman walks through how default works step by step for the benefit of someone who probably thinks YouTube comments count as legal citations. He explains that since the defense responded with a timely motion, there's no default. Period. This is where sovereign citizens trip over their own arguments. They weaponize half-understood legal terms, hoping technicalities will win them the day. But courts don't operate on fantasy. Coleman is laying down facts, and Grayson is clearly outmatched. The judge might as well be explaining gravity to Someone trying to levitate.
What are you that you are saying and what is pertaining to? We are still ready to proceed with the case.
What, what exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, I'm in traffic court 936 district. There's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
All right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, but it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing.
And there it is, the infamous right to travel argument. This is a sovereign citizen classic. Grayson's case isn't about misconduct or civil violations. It's about his belief that he shouldn't be stopped while driving because he's free to travel. That sounds noble until you realize it ignores all traffic laws, licensing rules, and public safety measures. Grayson's entire lawsuit crumbles right here. The Courtroom isn't a podcast for fringe ideologies, it's a forum for legitimate grievances backed by legal precedent. And right now, he's got neither. The only thing traveling fast is this case straight to the...
That you failed to state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular.
Grayson doubles down, now claiming he's defending his birthright in a traffic court case that has absolutely nothing to do with citizenship status or human rights. This is the sovereign citizen spiral in action where logic takes a backseat and delusion rides shotgun. You can see Judge Coleman trying to translate nonsense into law, but it's like catching smoke. Grayson isn't just misinformed, he's entrenching himself deeper with every sentence. What started as a civil suit over a traffic stop is now an existential argument about national identity. And spoiler alert, it won't